Breaking news from California. Governor Gavin Newsom just signed a controversial new gun bill that could mark the beginning of mass firearm confiscations in the United States. It's called AB 1344, and while the mainstream media calls it a simple safety pilot, legal analysts are warning that it quietly grants the state power to seize firearms without a criminal conviction, and in some cases, even without a hearing. In this video, we'll break down exactly what's in this law, what it means for every gun owner in America, and how it could reshape the future of the Second Amendment. Welcome to Firearms Explained, where we decode every law, every case, and every decision that affects your right to keep and bear arms. Let's dive in. Part 1. The signing and what AB 1344 really does. On October 10th, 2025, Governor Gavin Newsom signed Assembly Bill 1344 into law. It's officially titled Restrictions on Firearm Possession, Pilot Project. The law creates a so-called pilot program in 4 California counties: Alameda, El Dorado, Santa Clara, and Ventura, allowing local district attorneys to petition the court for emergency gun violence restraining orders, or GVROs. Under this program, if someone is accused of being a potential danger, or simply fails to respond to a court notice, the DA can move forward with a petition to confiscate or permanently dispose of their firearms. Critics are calling it confiscation through paperwork, because even if the person never committed a crime, missing the 30-day response window could mean losing their guns forever. What makes AB 1344 stand out is how quietly it expands the power of government attorneys. For the first time, prosecutors, not police, not family members, can initiate confiscation petitions on behalf of the state. And once the order is filed, the person's right to possess, buy, or even touch a firearm is automatically suspended until the case is resolved. Gun rights advocates are warning that this is how confiscation begins, not with door-to-door raids, but through administrative courts under the banner of public safety. The law runs until 2032, and during that time, the state will gather data on how many firearms are seized, how many orders are renewed, and how often citizens fail to respond. A test run for possible statewide expansion. And if the numbers look effective to Sacramento, you can bet other states will follow. Part 2. The legal framework and history behind it. To understand why AB 1344 matters, you have to look at California's history with gun violence restraining orders. The GVRO system began in 2014 after the Isla Vista shooting. It allowed police or close family members to ask a judge to temporarily take away someone's guns if they were considered a threat to themselves or others. Supporters said it was about prevention. Opponents said it lacked due process. Fast forward a decade, and California now has one of the broadest red flag systems in the nation. Teachers, coworkers, employers, and even neighbors can request these orders. But AB 1344 goes further. It gives district attorneys direct confiscation power and, here's the key, adds a default clause. If a person doesn't answer the court notice within 30 days, they're treated as if they consented to the seizure. No hearing, no testimony, no chance to explain. That clause, experts say, flips the presumption of innocence on its head. For decades, the right to keep and bear arms depended on the state proving why you couldn't. Now it depends on you proving why you should, and doing so on time. The pilot also mandates data collection by the UC Davis Firearm Violence Research Center, meaning the entire program doubles as a social experiment. In plain English, AB 1344 is not just a law, it's a test. A test to see how far the state can go in seizing firearms under administrative law without triggering a constitutional backlash. Part 3. How this impacts gun owners. Let's talk about how this actually affects you. If you live in one of the pilot counties, you're automatically under a new kind of legal radar. A district attorney who believes, or is told, that you're a potential risk can file a petition. You'll receive a notice by mail. From that day, the clock starts ticking. 30 days to respond. Ignore the notice, miss the deadline, or misunderstand the paperwork, and your firearm can be confiscated by court order. No trial, no arrest, no defense. Once the order is granted, The state notifies the Department of Justice, and your name is entered into the prohibited persons database. The order can last up to 5 years and can be renewed indefinitely. And here's what most people don't realize. Even if the accusation was false, it can take months, even years, to get your property back. For concealed carry holders, competitive shooters, and collectors, this creates an enormous chilling effect. The risk of being labeled or defaulted on can make people hesitant to exercise their rights at all. It's why critics call AB 1344 a form of civil disarmament, a way to strip rights without the political cost of a full gun ban. Part 4. The National Ripple Effect. Now let's zoom out, because this isn't just about California. Historically, California has been the testing ground for most modern gun control laws, from magazine bans to background checks to assault weapon definitions. What starts as a pilot here often becomes federal inspiration later. Gun control advocates in states like New York, New Jersey, and Illinois are already praising AB 1344's design, calling it a responsible data-driven model for risk-based firearm removal. But what they're really saying is, we finally found a way to seize guns without a headline that says confiscation. At the same time, Second Amendment lawyers are preparing lawsuits arguing that AB 1344 violates both the Fourth Amendment, protection against unreasonable seizure, and the Second Amendment right to keep and bear arms. If those cases reach the Supreme Court, we could see a landmark ruling defining how far states can go with red flag laws. Until then, California becomes a live laboratory for government-initiated gun removal. For gun owners across America, this means one thing. What happens in California won't stay in California. Part 5. Protecting your rights and what's next. So what can you do right now to protect yourself? First, know your rights. If you live in or near one of the 4 pilot counties, learn the procedures, deadlines, and appeal rights under AB 1344. Second, respond immediately to any legal notice. Don't ignore it. Don't wait. Get legal advice fast. Third, organize. Join your local Second Amendment associations, stay connected with firearm rights attorneys, and keep track of how your DA's office implements this law. Fourth, stay informed. This pilot runs until 2032, meaning every year, data will shape future legislation. Finally, remember this. The strength of the Second Amendment has always depended on citizens who know the law, follow it, and defend it when it's twisted against them. AB 1344 may call itself a pilot program, but make no mistake, it's a blueprint. And what happens next depends on how gun owners respond. Knowledge is power. Responsibility is freedom. And understanding the law is the first step to protecting your rights. This is Firearms Explained, where we break down the facts, defend the Constitution, and make sure the truth stays louder than the politics. Stay alert, stay informed, and as always, stay free.